जय जगन्नाथ सामने वेलकम टू माय यूट्यूब चैनल। आज हम पढ़ा जाऊे साइलेंट फीचर ऑफ द कॉन्स्टिट्यूशन। फर्स्ट आसला द इंडियन कॉन्स्टिट्यूशन इज यूनिक इन इट्स कंटेंट्स एंड स्पिरिट्स थ्रो borrowed from almost every constitution of the world. The constitution of India has several silent features that distinguish it from the constitution of the other countries. It should be noted at the outset that a number of original features of the Constitution adopted in 1949 आम कन्स्टिट्यूशन के आडप्टेड कराया 1949 मसीहा नवेम्बर 26 तारीख में have undergone a substantial change and account of several amendment. पर्टिकुलर कौन amendment अच्छी ना 7th 42 44 73 and 74 97 and 101 amendment. In fact, the 42 Amendment Act 1976 is known as mini constitution. 42तम संविधान जो आमेंडमेंट होता 1976 मसीह आमर मिनी कन्स्टिट्यूशन नाम नामित कराइला ड्यू टू द इम्पोर्टेंट एंड लार्ज नंबर ऑफ changes made by it in various parts of the constitution. However, in the Kesavananda Bharati case 1973, the Supreme Court ruled that the constituent power of Parliament under the Article 368 does not enable it to alter the basic structure of the constitution. तार आसला साइलेंट फीचर गुड़िक केत अच्छी जोरा जोरा इम्पोर्टेंट सेरा मत कौच जोटा जोटा इम्पोर्टेंट नहीं सेरा मुझे कहबी। फास्ट आसला लेंथेस्ट एंड रिटेन कन्स्टिट्यूशन। भारतर संविधान हूँ द कन्स्टिट्यूशन आर क्लासिफाइड इनटू रिटेन लाइक द अमेरिकन कन्स्टिट्यूशन एंड अनरिटेन लाइक द ब्रिटिश कन्स्टिट्यूशन। The Constitution of India is the lengthest of all the written constitution of the world. It is a very comprehensive, elaborated and detailed document. Originally, 1949 मसीह the Constitution contained a preamble, 395 articles divided into 22 parts and 8 schedules. Presently, it consists of a preamble about 470 articles divided 25 parts and 12 schedules. The various amendments carried out since 1951 have deleted about 20 articles and 1 part and added about 95 articles and 4 parts. से 4 part कौन ना 4A 9A 9B and 14A and 4 scheduled 9 10 11 and 12. No other constitution in the world has so many articles and schedules. The part important articles and schedules of the Constitution of India are mentioned in 4 factors are contribution to depend on the size of the our constitution. They are geographical factor अच्छी historical factor अच्छी गोटे single constitution and dominance. First is the geographical factors, that is the vastness of the country and its diversity. Historical factor, the influence of the Government of India Act 1935, which was blockly single constitution for both the center and the state. Dominance of legal luminaries in the Constitution Assembly. The Constitution contains not only the fundamental principle of governance but also deleted administration provisions. Further, those matters which in other modern democratic countries have been left to the ordinary legislature to establish political conservation have also been included in the Constitution document itself in India. Then as a blend of rigidity and flexibility. Constitution are also classified into rigidity and flexibility. A rigidity constitution is one that requires a special procedure for its amendment, as for example the American Constitution. Except a flexible constitution, on the other hand, is one that can be amended in the same manner as the ordinary law are made, as for example British Constitution. The Constitution of India is neither rigidity nor flexibility, but a synthesis of both. इंडियन कॉन्स्टिट्यूशनटा नाइदर रिजिडिटी नॉर फ्लेक्सिबिलिटी किंतु एटा बोथर सिंथेसिसटा आर्टिकल 368 प्रोवाइड्स फॉर टू टाइप्स ऑफ अमेंडमेंट फर्स्ट आसला सम प्रोविजन कैन बी अमेंडमेंट बाय ए स्पेशल मेजॉरिटी ऑफ द पार्लियामेंट 2/3 majority of the member of each house present and voting and a majority of the total membership of each house. Some other provisions can be amended by a special majority of the parliament and with the ratification by half of the total states. At the same time, some provisions of the constitution can be amended by a simple majority of the parliament in the manner of ordinary legislative process. Notable these amendments do not come under Article 368. Federal system with unitary basis. The Constitution of India establishes a federal system of government. It contains all the usual features of a federation: two governments, division of power, written constitution, supreme the constitution, rigidity of the constitution, independent judiciary and bicameralism. ये सब लक्षण गुड़ रही संघीय राष्ट्र. However, the Indian Constitution also constitutes many unitary or non-federal features: a strong center, single constitution, single citizenship, flexibility of the constitution, integrated judiciary, appointment of state governor by the center, all India service, emergency provisions, and so on. Moreover, the term federation has now here been used in the Constitution. Article 1, on the other hand, describes India as a union of the states, which implies two things. One, the Indian Federation is not the result of an agreement by the state, and two, no state has the right to escape from the Federation. Hence, the Indian Constitution has been variously described as federal in form but unitary in spirit, quasi-federal by Casey Ware, bargaining federalism by Morris Jones, cooperative federalism by Granville Austin, federation with a centralizing tendency by Ivor Jennings, and so on. The parliamentary form of government. The Constitution of India was opted from the British parliamentary system of government rather than the American presidential system of government. The parliamentary system is based on the principle of cooperation and coordination between the legislative and executive organs, while the presidential system is based on the doctrine of separation of power between the two organs. The parliamentary system is also known as the Westminster model of government, responsible government, and cabinet government. The Constitution established the parliamentary system not only at the center but also in the state. Parliamentary system किछि गुड़िए फीचर अच्छी इंडिया कौन ना प्रेजेंस ऑफ नॉमिनल एंड रियल एग्जीक्यूटिव, सेकेंड मेजॉरिटी पार्टी रूल, थर्ड कलेक्टिव रेस्पॉन्सिबिलिटी ऑफ द एग्जीक्यूटिव to the legislature, fourth membership of the minister in the legislature, then leadership of the prime minister or the chief minister, dissolution of the lower house Lok Sabha or assembly, then asila integrated and independent judiciary. The Indian Constitution established a judiciary system. भारतर संविधान न्याय को आधार करके गठन करा that is integrated as well as independent. The Supreme Court stands at the top of the integrated judiciary system in the country. Supreme Court सर्वोच्च शासन क्षमता अधिकार पाई आम देश में. बिलो ताप तले अच्छी हाई कोर्ट एंड तापर अच्छी स्टेट लेवल को जोटा कि हाई कोर्ट राज्य सरकार हिसाब से जाऊँगी. अंडर द हाई कोर्ट देयर इज हेरिज ऑफ सबऑर्डिनेट कोर्ट. हाई कोर्ट तले मध्य केते छोट छोट सबऑर्डिनेट कोर्ट अच्छी. तापर तो डिस्ट्रिक्ट कोर्ट छोट छोट जिला कोर्ट मध्य अच्छी एंड अदर लोअर कोर्ट. दिस इज सिंगल सिस्टम ऑफ कोर्ट्स एनफोर्स बोथ द सेंट्रल लॉ as well as the state law, unlike in USA, where the federal law are enforced by the federal judiciary and the state law are enforced by the state judiciary. The Supreme Court is a federal court. the highest court of appeal, the guarantor of the fundamental rights of the citizens and the guardian of the Constitution. Hence, the Constitution has made various provisions to ensure its independent security of tenure of the judges, fixed service condition for the judges, all the expenses of the Supreme Court judges on the Consolidated Fund of India, prohibition on discussion on the conduct of judges in the legislature, ban on practice after retirement, power to punish for its contempt vested in the Supreme Court, separation of the judiciary from the executive and so on. Then ଆସିଲା fundamental rights. Constitution fundamental right ମଧ୍ୟ ଗୋଟେ main feature जोटाकि आमर पार्ट 3 रे अच्छी द इंडियन कॉन्स्टिट्यूशन ग्यारंटी 6टा फंडामेंटल राइट देछि नागरिक माननकु सबु नागरिक माननकु फर्स्ट आसला राइट टू इक्वालिटी आर्टिकल 14 रु 18 राइट टू फ्रीडम आर्टिकल 19 रु 22 राइट अगेंस्ट एक्सप्लॉयटेशन आर्टिकल 23 रु 24 राइट टू फ्रीडम ऑफ रिलीजन आर्टिकल 25 रु 28 कल्चरल एंड एजुकेशनल राइट आर्टिकल 29 रु 30 राइट टू कॉन्स्टिट्यूशनल रेमेडीज जोटा कि आमर आर्टिकल 32 रे रही. Originally the constitution provide for 7 fundamental rights. However the right to property जोटा कि आमर आर्टिकल 31 रे थिला ताको आमर डिलीट करा जायछि deleted from the list of a fundamental right by the 44th Amendment Act 1978. It is major legal right under Article 300A in Part X second I of the Constitution. The fundamental rights are meant for promoting the idea of political democracy. They operate as limitation on the tyranny of the executive and arbitrary law of the legislature. They are justiciable in nature, that is, they are enforceable by the court for their violation. The aggressive person can directly go to the Supreme Court, which can issue the writs of habeas, mandamus, prohibition, certiorari, quaranto. ये 5टी रिट दिए जो कि माने जो आर्टिकल 32 अच्छे से रेमेडीज मध्यम आम सुप्रीम कोर्ट को द्वारस्थ हो पार. ये 5टा रिट मध्य जो जोटा तुम प्रोब्लेम होता है से अनुसार तुम सुप्रीम कोर्ट को जाकि निजर प्रोब्लेम को जन पार अधिकार दी जाइए फंडामेंटल राइट रे. हाउएवर द फंडामेंटल राइट आर नॉट एब्सोल्यूट एंड सब्जेक्ट टू reasonable restriction. Further, they are not sacrosanct and can be curtailed or replaced by the Parliament through a Constitution Amendment Act. They can also be suspended during the operation of a national emergency, except the right guaranteed by the Article 20 and 21. माने जो आमर संविधान जिते भारत में नेशनल इमरजेंसी लागू कर फंडामेंटल राइट सबू सस्पेंड हो पार किंतु आर्टिकल 20 और 21 को छाड़ी. Then आसला आमर डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी अकॉर्डिंग टू डॉक्टर बी आर आम्बेडकर. द डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी जोटा कि आमर आर्टिकल 36 रु 51 मध्य अच्छी. ये डीपीएसपीटा हूँ आमर गोटे नोबेल फीचर ऑफ द इंडियन कॉन्स्टिट्यूशन. दे आर enumerated in part 4 of the constitution. They can be classified into 3 broad categories. गोटे हूँ socialist, guardian और liberal intellectual. The directive principles are meant for promoting the idea of social and economic democracy. They seek to establish a welfare state in India. However, unlike the fundamental rights, the directives are non-justiciable in nature, that is, they are not enforceable by the courts for their violations. Yet the Constitution itself declares that these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making law. Hence, they impose a moral obligation on the state authority for their application, but the real force behind them is political, that is, public opinion. In the Minerva scales 1980, the Supreme Court held that the Indian Constitution is founded on the bedrock of the balance between the fundamental rights and the directive principle of state policy. Next, fundamental duty. The original constitution did not provide for the fundamental duty of the citizens. These were added during the operation of international emergency 1975 to 77 by the 42nd Constitutional Amendment Act of 1976 on the recommendation of the Swarna Singh Committee. The 86th Constitutional Amendment Act, the 2002, added one more fundamental duty, Part 4A of the Constitution, which consists of only on Article 51A, specifying the 11th fundamental duty to respect the Constitution and national flag and national anthem, to protect the sovereignty, unity and integrity of the country. फंडामेंटाल ड्यूटी कम कराइए आम आमर जो मौलिक कर्तव्य अच्छी आम कि पालन करवा जमीक आम संविधान को सम्मान देवा नेशनल फ्लैग को सम्मान देवा नेशनल आंथेम को सम्मान देवा सार्वभौम लोक आम समस्त सार्वभौम समस्त को समस्ते प्रोटेक्ट करवा आमर नेशनल यूनिटी को रक्षा करवा आम देशर एकता को रक्षा करने ये फंडामेंटाल ड्यूटीटा को आमर संविधान ऐड कर to promote the spirit of common brotherhood among the people, to preserve the rich heritage of our culture, and so on. The fundamental duty serve as a reminder to citizens that while enjoying their rights, they also have to be quite conscious of duty they owe to their country, their society, and to their fellow the citizens. And however, like the directive principle, the duty are also non-justiciable in nature. Then asila the secular state. The Constitution of India stands for a secular state, hence it does not uphold any particular religion as the official religion of the Indian state. The following provisions of the Constitution reveal the secular character of the Indian state. The term secular was added to the preamble of the Indian Constitution by the 42nd Constitutional Amendment Act 1976, and the preamble secures to all citizens of Indian liberty of belief, faith and worship. The state shall not deny to any person equality before the law or equal protection of the law. Article 14. And the state shall not discrimination against any citizens on the ground of religion. Article 15. And equality opportunity for all citizens in matters of public employment. Article 16. All persons are equally entitled to freedom of conscience and the right to freely profess, practice and propagate any religion. Article 25. Every religion, domination or any of its sections shall have the right to manage its religion affairs. Article 26. No person shall be compelled to pay any taxes for the promotion of a particular religion. Article 27. And no religion institution shall be provided in any educational institution maintained by the state. Article 28. Any section of the citizen shall have the right to conserve its distinct language, script or culture. Article 29. And all minorities shall have the right to establish and administration educational institution of their choice. Article 30. The state shall endeavour to secure for all the citizens a uniform civil code. Article 44. The Western concept of secularism contains a complete separation between the religions, the church and the state. This negative concept of secularism is inapplicable in the Indian Constitution where the society is multi-religious. Hence, the Indian Constitution embodies the positive concept of secularism, giving equal respect to all religions or protecting all religions equally. ସବୁ ଧାର୍ମିକ ଲୋକମାନଙ୍କୁ ସମାନତା ଆଧାରରେ ଦେଖାଯାଏ ସେକୁଲାରିଜିମରେ. And moreover, the constitution has also abolished the old system of communal representation, that is, reservation of seats in the legislature on the basis of religion. However, it provides for the temporary reservation of seats for the scheduled caste and scheduled tribes to ensure adequate representation to them. That was the universal adult franchise. The Indian Constitution adopts universal adult franchise as a basis of election to the Lok Sabha and the state legislative assembly. Every citizen who is not less than 18 years of age has a right to vote without any discrimination of caste, race, religion, sex, literary wealth, and so on. The voting age was reduced to 18 years from 21 years in 1989 by the 61st Constitution Amendment Act 1988. The introduction of universal adult franchise by the constitution makers was a broad experiment and highly remarkable in review of the vast size of the country, its hug population, high poverty, social inequality, and overwhelming illiteracy. Universal adult franchise makes democracy broad-based, enhance the self-respect and the prestige of the common people, upholds the principle of equality, enables minorities to protect their interests, and opens up new hopes and vistas of weaker section. ମାନେ ଏଇ ଯେଉଁ ୟୁନିଭର୍ସାଲ ଆଡଲ୍ଟ ଫ୍ରାଞ୍ଚାଇଜ୍ରେ ସେ କ'ଣ କହିଲେ ନା ସମସ୍ତେ ସମାନ, ସମସ୍ତେ ଭୋଟ୍ ଦେଇପାରିବେ. 18 ବର୍ଷରୁ ଅଧିକ ଲୋକମାନେ କାଷ୍ଟ, ରେସ୍, ରିଲିଜିୟସ୍ ସେକ୍ଟରରେ ସମସ୍ତେ ଭୋଟ୍ ଦେଇପାରିବାର ଅଧିକାର ଅଛି. ଆଉ ସମସ୍ତେ ସବୁଥିରେ ଭାଗ ନେଇପାରିବେ. ଏ ବିଷୟରେ ଏଥିରୁ କୁହାଯାଇଛି ସମସ୍ତଙ୍କୁ ଇକ୍ୱାଲିଟି ବା ସମାନତା ଦିଆଯାଇଛି. ଇଣ୍ଡିଆନ୍ କନଷ୍ଟିଟ୍ୟୁସନ୍ ଆଉ ଗୋଟେ ମେନ୍ ଅବଜେକ୍ଟିଭ୍ ହେଉଛି ସିଙ୍ଗଲ୍ ସିଟିଜେନସିପ୍. ଥ୍ରୁ ଦ ଇଣ୍ଡିଆନ୍ କନଷ୍ଟିଟ୍ୟୁସନ୍ ଇଜ୍ ଫେଡେରାଲ୍ ଆଣ୍ଡ envisages a dual polity, center and state. It provides for only a single citizenship, that is the Indian citizenship. ମାନେ ଗୋଟେ ବ୍ୟକ୍ତି ଗୋଟେ ରାଜ୍ୟର ଆଉ କେନ୍ଦ୍ରର ଲୋକ ନାଗରିକ ହେଲେ ମଧ୍ୟ ତାକୁ ଗୋଟେ ସିଙ୍ଗଲ ବା ଏକକ ନାଗରିକତା ବୋଲି କୁହାଯାଏ କି ସେ ହେଉଛି ଜଣେ ଭାରତୀୟ ନାଗରିକ. In countries like USA, on the other hand, each person is not only a US citizen but also a citizen of the particular state to which he belongs. Thus, he was eligible to vote and enjoy dual status of rights, one conferred by the national government and other by the state government. In India, all citizens, irrespective of the state in which they are born or reside, enjoy the same political and civil rights of citizenship all over the country, and no discrimination is made between them. Dispute the constitution provision for a single citizenship and uniform right from all the people. India has been witnessing communal road class conflict, caste wars, linguistic clash, and ethnic dispute. This means that the cherished goal of the constitution makers to build a united and integrated Indian nation has not been fully realized. Then asla independence body. The Indian Constitution not only provides for the legislative, executive, and judiciary organs of the government, central and state, but also establishes, creating the independent body. They are invested by the Constitution as the bulwarks of the democratic system of government in India. They are election commissioner to ensure free and fair election to the parliament of the state legislature, of the office of president of India and the office of vice president of India. Then as the comptroller, auditor general of India to audit the account of the central and the state government. He acts as the guardian of public reports and comment of the legality and property of the government expenditure. Union Public Service Commission to conduct examination for requirement of all India service and higher central service and to advise the President on disciplinary matters. State Public Service Commission in every state to conduct the examination for requirement to state service and to advise the governor on disciplinary matters. Emergency provision. The Indian Constitution contains elaborate the emergency provisions. भारत तीनटा emergency provision ଅଛି, ଗୋଟେ national, state ଆଉ ଗୋଟେ ଅଛି financial emergency. The Indian Constitution contains elaborate emergency provision to enable the President to meet any extraordinary situation effectively. The rationality behind the incorporation of these provisions is to safeguard the sovereignty, unity, integrity and security of the country, the democratic political system and the Constitution. The Constitution envisages three types of emergency, namely national emergency on the ground of war or external aggression or armed rebellion, Article 352. State emergency president rule जो लागू करा जाए on the ground of failure of constitution machinery in the state, Article 356, or failure to comply with the direction of the center, Article 365. And the financial emergency in the ground of threat of the financial stability or credit of India, Article 360. The government originally the Indian Constitution, like any other federal constitution, provide for dual polity and contain provision with regard to the organization and power of the center and the state. Later, the 73rd and 74th Constitution Amendment Act 1992 have added a third tier of government, which is not found in any other constitution of the world. The 73rd Amendment Act of 1992 gave constitutional recognition to the Panchayat rural local government by adding a new part IX and a new Schedule 11 to the constitution. This part provides for a three-tier system of Panchayat Raj in every state. Panchayat at the village, intermediate and the district level. Similarly, the 74th Amendment Act of 1992 gave constitutional recognition to the municipality urban local government by adding a new part IXA and a new Schedule 12 to the constitution. This part provides for the three types of municipality in every state: Nagar Panchayat for a transactional area, municipal council for a smaller urban area, and municipal corporation for a larger urban area. National Cooperative Society. The 97th Constitution Amendment Act 2011 gave a constitutional status and protection to cooperative society. In this context, it's made the following three changes in the Constitution. First, slightly made the right to form cooperative society a fundamental right, Article 19. Second, it includes a new directive principle of state policy on promotion of cooperative society, Article 43b. Third, it added a new part IXB in the Constitution, which is entitled the Cooperative Society, Article 243Z to 243ZT. The new part IXB contains various provisions to ensure that the cooperative society in the country function in a democratic, professional, autonomous and economically sound manner. It empowers the parliament in respect to multi-state cooperative society and the state legislature in respect of other cooperative society to make the appropriate law. ଏଇଟା ଥିଲା ଆମର ସାଇଲେଣ୍ଟ ଫିଚର। ଯଦି ଭିଡ଼ିଓଟି ଭଲ ଲାଗିଥାଏ ତାହେଲେ ମୋ ଚ୍ୟାନେଲଟିକୁ ଲାଇକ୍ ଆଣ୍ଡ ସବସ୍କ୍ରାଇବ୍ କରିବାକୁ ଜମା ଭୁଲିବେନି। ଧନ୍ୟବାଦ।